This audit is an audit that we issued in late October. Again, this audit was requested of the Audit Committee back in March of this year. We issued the report on October 29th. This audit, the scope of this audit was asking us to look at the process for identifying armed prohibited persons with a mental illness in California. And there are various agencies that are involved in this process. Certainly the Department of Justice has a major role, but we were also asked to look at a sample of courts in California as far as whether or not they were meeting their reporting responsibilities, as well as mental health facilities in California. So those three respective entities are what was included in the scope of the audit. And this audit was, again, related to prohibitions with respect to mental illness. There are other types of prohibitions that would require the state to confiscate a weapon from an individual, but again, the focus here was on mental health. The Armed Prohibited Persons database is something that was established in November of 2006. The Department of Justice is responsible for maintaining that system. Essentially what happens is if an individual is involuntarily committed, for example, to a mental health facility because of a serious mental illness, that facility is to report that information to the Department of Justice. What the Department of Justice then does is matches that individual to its registry of firearms owners, and if there is a match, there's the potential that that person should be deemed a prohibited person. What DOJ has to do is make sure that the person who was reported by the mental health facility, and if it's a Bruce Smith, for example, and the Bruce Smith firearm owner, they have to make sure it's the same individual, and then they make that determination that that person is prohibited, and then that individual should have his or her weapon confiscated because of their prohibition. So the first discussion I'm going to talk about or explain to you are the findings related to the courts. We had three key issues related to the courts. First of all, what we did is we talked to the Department of Justice and looked at their database, their mental health database, to determine how many of these types of reports they had received from the courts for 3 years, 2010, 2011, 2012. And what was surprising to us is we saw many courts that had very low numbers of individuals who had been reported to justice. There were 34 courts that had real low numbers, so we chose to survey those courts to determine, number one, first of all, were they aware of their reporting requirements? And surprisingly, 29 of those 34 courts were not aware of the reporting requirements that they should be reporting an individual, for example, who had been deemed mentally incompetent to stand trial. That determination made in that court triggered a reporting requirement. They should have been reporting those individuals to the Department of Justice so Justice could then do the matching to determine whether or not that individual owned a firearm and whether or not that weapon should be confiscated. Relatively shortly after the audit was approved, again, it was approved in March of 2013, credit to the AOC, they reached out in April of 2013 to the Department of Justice to get a better understanding of the reporting requirements so that they could then reach out to the courts and contact the courts and educate them about their reporting requirements. So again, the audit triggered immediate response by respective agencies in the state, and DOJ worked with AOC to make sure that AOC understood the reporting requirements so that guidance that went out to the courts was the correct guidance, and courts were aware of their reporting requirements. So that was one key finding that we had, quite surprising that the courts were not aware of their reporting requirements. Now, we actually decided to do some testing, as we were requested to do, at 3 courts to make sure that those courts that, in fact, were reporting all of the individuals they should have been reporting. We visited 3 courts, LA, San Bernardino, and Santa Clara, and we found that these courts were not reporting all of the determinations that they should have been reporting. They were reporting. They were aware of the reporting requirements, but unfortunately they were not reporting all the individuals they should have. In particular, there's a LA mental health courthouse that handles a lot of cases related to individuals who have a mental illness that may deem them incompetent to stand trial. And for some of the cases that we looked at that should have been reported, we found a fairly high number that had not been reported, certainly of our selection or our sample, that had not been reported to justice. But again, it was LA, San Bernardino, and Santa Clara, and all three courts had problems where they were not reporting all the individuals they should have been reporting. The third issue related to the courts is the timeliness of the reporting. The state law, as it stands right now, and it will be changing January 1st of next year, just a few weeks away, excuse me, we're not timely reporting reporting information to the Department of Justice. The state law right now says that those reports should be made immediately. What we found when we talked to some of the courts, and certainly the three courts that we visited, is their interpretation of that varied. Some courts said that's within 2 court days, some said it's within 7 days. But what we decided to do is test against what their interpretation of immediately was, and we found, again, all three courts were not even meeting their own interpretation of immediately. So if their interpretation was 2 court days, they were not meeting that, and quite often they were exceeding that by at least 3 or 4 more days, in some cases as many as 6 days. So we had concerns there. The statute is changing. Assemblymember Skinner authored legislation that will take effect in January 1st of 2014, which will now require mental health facilities to report within 24 hours. So immediately goes away. 24 hours is somewhat equivalent to immediately. Courts are now going to be allowed 2 court days. The reason I bring this up is we have a recommendation to the legislature. We think there should be consistency, and we have concerns with the 2 court days. Even though the courts weren't meeting their own interpretation, we think this is a serious enough issue that they should be required to report similar to mental health facilities within 24 hours. Also, what Assemblymember Skinner's bill does is requires courts to report electronically. Mental health facilities have been required to report electronically since July of 2012, and what we saw when we looked at that, especially when we looked before that reporting requirement and subsequent, that really did improve the timeliness of the reporting by mental health facilities. So we think now that the courts are going to be required to report electronically, hopefully that improves their reporting timeliness as well. But we still stand by our recommendation. We think the courts should be required to report within 24 hours, similar to what mental health facilities are required to do. So those were the 3 key issues for the courts. We really didn't have a lot of recommendations or concerns with mental health facilities. As I said, as of July 1st, 2012, they were required to use an online system. They were mandated. Prior to that, it was voluntary. And we did see improvement in the timeliness on behalf of the mental health facilities as far as how quickly they were reporting the information to the Department of Justice, so Justice could do that matching and determine if these people were actually prohibited persons who owned a firearm. The other department that we looked at, of course, is the Department of Justice. And we had 3 key areas that we looked at with respect to Department of Justice. One is reporting. And I'll talk a little bit about the issues we had there. The second is the processing of the information once they receive it from the respective reporting entities, courts, mental health facilities. And then a brief discussion on confiscation. We did not look a lot at confiscation, but we did have like a page and a half in the report to talk a little bit about the status, and certainly acknowledging the legislature's appropriation of funds to allow the Attorney General to hire more agents to be able to get out there and confiscate weapons. But let's step back to reporting. So with respect to the Department of Justice, we felt the Department of Justice needed to do a better job of reaching out to courts and educating them of the reporting requirements. DOJ is saying, well, AOC is in a good position to do that. They provide guidance to courts. But we think that Justice needs to partner with AOC. Justice is the entity that knows how many reports they're getting from the various courts. Are they seeing a drop-off in the number of reports that they're receiving? That might trigger at least a question to that particular court if there's been a change in jurisdiction or something, or are the courts not realizing the types of individuals they should be reporting? So we think Justice needs to do a better job in reaching out to courts, reminding courts of the specific requirements. With respect to mental health facilities, we actually did a match where we took the mental health facilities that the Department of Justice had for which they were receiving reports and compared that to the list of licensed facilities that is currently under Healthcare Services. Prior to a year or so ago, it was under Social Services. But anyway, we took the list of licensed facilities that would treat individuals, for example, who may be involuntarily committed to a psychiatric facility because of a mental illness, to determine whether or not DOJ had all of the mental health facilities in its database that should be reporting. And what we found is we identified 22 facilities that had been licensed by the state of California that was not on DOJ's list. And we thought that was an important finding because DOJ needs to have a complete list so that they can monitor the types of reports that they're getting from these mental health facilities, and again remind the mental health facilities of the reporting requirements. Particularly if you see a situation where a mental health facility is reporting individuals, and similar to what I said about the courts, you see a drop-off. You can reach out to that mental health facility to make sure that has there been a change in administration or staffing where they don't realize what their reporting requirements are. So again, it's a good monitoring mechanism that DOJ could use. So we think they need to do this matching with Healthcare Services list of licensed facilities. So that's something that we have encouraged in our recommendations Department of Justice to do. In addition, they need to provide more training. They've provided 2 statewide trainings for mental health facilities, one in 2007 and recently in 2012. So again, seeing changes in the reporting numbers may trigger additional training needs. It may identify additional training needs. So those were the key issues that we had related to justice and making sure they know the list of mental health facilities, and then conducting training and making sure that they're monitoring or tracking the reporting levels that these mental health facilities are showing from year to year. On to processing. We had a variety of concerns with respect to processing. What we were finding is that Department of Justice was not inputting all of the information into its database. Also, some of the key decisions that staff were making as far as the analysis they were doing to determine here's the information we received from the mental health facility, here's this individual in the firearms database, should this person be prohibited, yes or no? And we sampled a few items, and we found 3 out of 8 that we sampled that the incorrect determination, they determined the person was not a firearm owner and should not have been prohibited, and that was a mistake. So what we looked for was some type of quality control, supervisory review of perhaps a sample of decisions that staff are making, and we didn't see that. So logically, we went to there needs to be some type of quality control to make sure that we're making the right, Department of Justice is making the right decision when they deem someone either prohibited or not prohibited relating to their ownership of firearms and their prohibiting event. In addition, we found that they were not using all of the information in the database. So if they had partial information, so a partial birth date, maybe the year, but they didn't have the month or the day, they decided not to use that information. So we're encouraging them to use as much information as possible that's in their database. A couple of things we talk about with respect to backlogs. The first backlog is kind of a daily, they have come up with a benchmark saying that if they can keep their daily backlog around 1,200 or below, that would be a good benchmark to hit. We had concerns with that. We looked at a year window, and we saw that in most cases they were well below the 1,200, so we've actually recommended that they drop that cap down to somewhere between 400 and 600. And I can explain why we think that's reasonable. So this backlog, as far as exceeding, in a few instances they exceeded the 1,200 cap. Specifically when they had to divert some of their staff who were working on these matches to conduct background checks of firearm, persons who wanted to purchase a firearm. But we, again, think that the cap can be reduced to this 400 to 600. Overall, the division, the APS unit, as it's called, did review these particular matches and got the assessment done within a relatively short period of time. On average, we saw they were only taking about 5 days to complete the review. So it's not like these individuals, these matches aren't happening or being resolved for a long period of time. On average, they're being done relatively quickly. The other backlog that we discuss in the audit report is a backlog of persons who are firearms owners where the Department of Justice needs to determine whether or not any of those individuals are a prohibited person. That backlog as of July of 2013 was about 380,000 individuals. Started out at 1 million, and this is firearms owners that they had determined they needed to do the match to determine whether or not any of these individuals would be a prohibited person. What Department of Justice estimated is that they would be able to get through that 380,000 number by 2016. When we looked at their production numbers, for lack of a better term, their process for identifying prohibited persons, we felt that it would take them at least until 2019 to be able to get through this backlog based on their performance at that point in time. One thing to note is that Justice did estimate that of these 380,000 folks, about 6% may actually end up being individuals who should be deemed a prohibited person due to a mental illness. So there are some individuals in there, and it's important for the Department to get through that backlog. So that's something that we have discussion in our recommendations as well. Last issue, confiscation. And again, this audit didn't look at the process for confiscating weapons, but we felt we wanted to give the legislature and the public at least a little bit of information related to the status. So since 2011, Justice had completed about 3 statewide sweeps. They had confiscated nearly 4,000 weapons. Again, as I mentioned earlier, in May of this year, the legislature appropriated an additional $24 million so that the Attorney General could hire more agents to have in their regional offices. There are 6 regions in the state these enforcement agents operate out of, and they go out and try to confiscate those weapons once that match has been completed. In addition, the Department of Justice has to report to the legislature on an annual basis how well they're doing in confiscating weapons. The first report is due March 1st of 2015. The reason it says 2015 is the legislature has asked for a full year, so that would reflect the full 2014 activity as far as confiscating weapons. When we issued our report, Justice had made progress, and I assume they'll be able to give you even more updated information. They were in the process of hiring some new enforcement agents. In fact, they were moving on at least 10 hires at that point in time, but it's my understanding that they have made more progress with respect to that. So going through the recommendations very quickly, because I know time sensitive, we do have the recommendation I mentioned to the legislature about amending the statute to require that all mental health related prohibiting events be reported within 24 hours regardless of the entity. This is related to the two court day requirement in Assemblymember Skinner's bill. The recommendation to the AOC is to coordinate with Justice at least once a year to obtain information about numbers that courts are reporting to see if there have been any changes from year to year. This will help AOC provide technical assistance to courts and certainly identify if there needs to be any additional training. Mental health facilities, we did not have any specific recommendations to mental health facilities. It's my understanding the Department of State Hospitals is now going to be reporting information to DOJ. In the past it was at DOJ's request. Now, so that's another change that I think is a positive change. Key recommendations to the Department of Justice related to reporting. They need to assess that court reporting information at least once a year and again work with AOC to determine whether there's additional bulletins or additional training that needs to be provided at the court level. Update their list of mental health facilities twice a year to make sure that they have the full listing of facilities that should be reporting these individuals to Justice. By January 31st, get that process established as far as doing the analysis of the mental health facility reporting, contact facilities to determine whether mental health facilities need any assistance or any additional training. Related to processing, making sure that they implement quality control procedures, supervisory oversight of individuals who are making some of these determinations to assure that staff are properly trained and that the determinations are correct. Again, Related to the daily queue, I think our recommendation is clear. Revise its goal from the maximum number of matches in the daily queue down from that 1,200 to somewhere between 400 and 600. The reason we're comfortable with that is we looked at a one-year window, June of 2012 to May of 2013, and 61% of the time they were below the 400 daily in the queue. 71% of the time they were below 600. So a significant amount of the time of that one-year window that we looked at, they were able to stay below the two benchmarks that we're suggesting, the 400 and the 600. And then finally, to meet its goal of eliminating that backlog of firearms owners, that 380,000 firearms owners that they need to investigate by the end of 2016, we just have a recommendation that they really need to pay attention and manage their staff resources as efficiently as they can so that they can meet that deadline. Again, we had concerns whether they would be able to do it by 2016 or that it would perhaps take longer than that. Similar to the report we talked about earlier, again, we would expect a 60-day response from the agencies. That would come in the end of this month. This report went out on October 29th. So by the end of this year, we should have the initial response from AOC, from the courts we visited, and certainly from the Department of Justice as to what they've done to implement our recommendations. So with that, I'll turn it back to the chair.
Thank you, Madam Auditor, for the presentation, all the work done by your office in respect to this audit. I'd like to, at this time, ask both the courts and representatives from the Department of Justice to join us up here, and I'd also like to welcome Assemblymember Mansour. We are currently on item 3, which of course is an audit that I co-authored with Assemblyman Mansour as well as Assemblymember Ashajian. And thank you for your work on this, sir, and thank you for being here with us. We've concluded the State Auditor's presentation. At this point, we're going to go ahead and ask the Department of Justice to make their presentation, and members will hold our questions till the end for the panelists. So, Department of Justice, please proceed.
Thank you, Chair, for the opportunity to come here today and discuss this audit. My name is Steve Lindley. I am currently the Bureau Chief for the California Department of Justice, Bureau of Firearms. I want to talk briefly about the audit. I want to thank the Auditor's Office for coming in and providing an opportunity for us to see how we can do our job a little bit better. We think that we do an excellent job at the Department of Justice, especially when it comes to our Armed and Prohibited Persons system and mental health. However, any suggestions for improvement is welcome. Thank you for the professionalism from your staff in order to identify some weaknesses in our system for us to move forward. Our Armed and Prohibited Persons system is very unique, not only in California, but in the nation. We stand alone in the ability to identify individuals who at one time lawfully purchased a firearm, but then became prohibited. We have that system through our Armed Prohibited Persons system, started in 2004 with legislation, and moved forward to implementation in 2007. Since then, the department has identified over 21,000 individuals who are currently on that system. We have investigated over 12,000 individuals in the state of California, confiscated over 13,000 firearms, and a little over 1.1 million rounds of ammunition from individuals. When the audit was put forth for the recommendations, we agreed with all the recommendations. The department can do a better job in several different areas, and we look forward to working with the Auditor's Office, the AOC, state services, the courts, and state mental health in order to achieve these recommendations. Thank you.
Thank you, sir. If the representatives from the courts would introduce themselves and proceed with your response.
Thank you, Mr. Chair, members of the committee. I am David Yamasaki. I'm the Court Executive Officer for the Superior Court in Santa Clara. I'm also appearing before you in two capacities. One as a court that was a subject of the audit, Santa Clara, but also as the chair of the Judicial Council's Court Executives Advisory Committee, which has a membership of all 58 court executives in our state. And first, relative to this audit, we in Santa Clara are very much in agreement with the findings that were presented in the report. It was clear that there are issues that we had to overcome in meeting this requirement. Nothing is more important to us than ensuring that individuals who have firearms are adequately and appropriately reported so that relinquishment can occur. But also, relative to our court, one of the findings that was presented was that the reporting within immediate reporting of the findings was critically important. We did our best to try to comply with that requirement. Clearly, it's something that we have identified, and even before the publishing of the report, we did implement new procedures to ensure that that requirement was met. And in many instances, the reporting requirement is occurring within that 48-hour period in advance of the statutory requirement takes effect on January 1st. But the other aspect that I wanted to report on is the challenge that we have on a statewide basis. Much like all of the other courts in California, we have tremendous limitations both in resources that affect our staffing levels, but also in the absence of technology to enable us to make the reporting as timely as possible. In my court alone, which is not unique, the reporting requirement is done on a manual basis. We have to produce a report, we verify that, and we have to put it in the mail to send off to Department of Justice. We simply don't have the technical ability to report this information on an electronic basis, which we would agree would expedite the process. Today, we don't have that. So we're relying upon the manual process, and of course that is a situation that many courts in California are facing, is not having the connectivity to the Department of Justice to make that reporting requirement. So we have no quarrel with the report. Clearly we need to do a better job. It's a very important issue, and we will endeavor to do so. The final point that I'd like to make is that the 48-hour requirement is going to be a terrible burden for many of the courts that have reduced their workforces by hundreds of employees. That is something that our court is experiencing alone, and many courts are down collectively in the thousands of employees. And by placing this 24-hour requirement on us, which is being proposed right now, I think it would be terribly challenging for us to even meet the 48-hour requirement, let alone the 24. My hope is that this body can consider giving us an opportunity to do a better job of reporting. The 48-hour requirement is something that we support, and hope that this body is in agreement that we need to do a better job of reporting, let alone adding on some additional requirements, which we simply do not have the capacity to expedite at this time.
Okay, thank you for your testimony. I understand we also have a representative from the Administrative Office of the Courts. Welcome, and please make your presentation.
Good morning, Mr. Chair, members of the committee. My name is Shelley Curran. I'm a senior manager with the Administrative Office of the Courts in the Criminal Justice Court Services Office. I'm just going to speak briefly about things that we have done since we learned of the audit, and then steps that we're going to take going forward in response to the recommendations of the state auditor. In May, we worked with Mr. Yamasaki and the chair of the Trial Court Presiding Judges Advisory Committee to get the information out to the courts, reminding them of this important requirement. We've worked with the Department of Justice as they've updated the forms that they subsequently sent out to the courts, and we reminded the courts at that time again, and that took place at the end of August, beginning of September. We've worked directly with over 22 courts. When we hit 22, we stopped counting, to work with the courts to assist them to meet this really important requirement. We are in the process now of examining our judicial education and court staff education to see where reminding the people who are involved with the courts of this important requirement, where it fits into that education process. Furthermore, my office is doing a comprehensive review of all of the firearms reporting requirements that are in the statute, and we're going to compile them in one place and disseminate that out to the trial courts. We've set up a system to meet quarterly with the Department of Justice to review with them how trial courts are doing in terms of compliance. Courts that are having a hard time with complying, our office will reach out directly to them and see if there's something that we can do to assist the courts. And we will continue to keep the legislature informed of the work that we're doing. And again, we very much appreciate working with the state auditor and the Department of Justice on this very important issue. I think it's very fair to say that the trial courts are certainly committed to and interested in making sure that people who are not supposed to have firearms underneath California law don't have access to them. And so we will continue this work. And thank you very much for the opportunity to speak with you.
Thank you for your testimony. At this time, we'll go ahead and open up for some questions from the members. Certainly, I think this couldn't be a more critical and important issue, particularly as this country reflects on the tragedy at Sandy Hook. As we sit roughly at the year anniversary, we've had yet another tragedy just in the past week. With gun violence, and certainly the extent to which we both track the prohibited persons list at the Department of Justice, but also effectively remove guns from the hands of those who are of danger to themselves and certainly a danger to the larger community is an extraordinarily important issue, and one that I know the members of this committee are deeply concerned about, which is why we authored this audit. So with that, I'd like to open up. Do any of the members have questions at this time? Senator Galgiani.
Well, first of all, thank you for all the work that all of you have done, and I think it's great for us to focus on mental illness. And the question I have goes in the direction of drug abuse as well, and mental illness that's induced by drug inducement or by drug abuse. So I'm wondering, because it talks here in the report about the determinations that the Superior Court makes on page 6 that they must make to the DOJ, and it speaks of a person who has been found by the court to be gravely disabled due to a mental disorder or impairment by chronic alcoholism. And I think in particular, methamphetamine is particularly dangerous because of the bipolar disorder that's created as a result of it. And so I'm just wondering if this reporting requirement captures that group of individuals who are temporarily mentally ill because of excessive meth use or other drug use, even though it's not expressly said here.
I would have to defer to court experts or legal experts to that, whether or not, I mean, I think you're referring to what's in the text box and
yes,
referring to Welfare and Institutions Code. So, again, I'm not a lawyer, so I wouldn't be able to opine on whether or not the statute includes those types of individuals. I think it would be up to, with all due respect, I'll defer to our court representatives and perhaps DOJ.
Thank you.
Yeah, unfortunately, I don't know the answer to that question. I think courts make determinations about an individual's any sort of mental disability, and presumably, if there was a mental disability that was related to drug abuse, if court found that there was a mental disability, then they would make a determination. But specifically in terms of methamphetamines and directly to your question, I'm sorry, I'm not able to answer that question now.
Okay, thank you. Anyone else? Want to jump in?
I think one of the key aspects that we have for our mental health system and in reporting people who are a danger to themselves or others, I think would really be a case-by-case basis for the court to look at if that person, although they might have mental health issues, if they pose a danger to themselves or others at the time of that determination. If they do, that should be reported to us. But again, it's on a case-by-case basis as what the judge or the court sees at that time.
So perhaps it's more of a question as to how the Welfare and Institutions Code is written, because since alcoholism is mentioned, it seems to me that meth use is far more dangerous than a mental illness as a result of alcoholism, or at least equally dangerous.
I would agree with that as a police officer, but I think we'd have to seek legal counsel for that as far as where would be the appropriate place to address that in our California codes.
Thank you.
Member Mansour.
Thank you, Mr. Chair. First of all, Mr. Chairman, I want to thank you and all the members of the committee for working cross-party lines on this important issue. It's a crucial issue to all of us in our state. And I also want to thank the auditor for your work on this important issue. I know it's time-consuming, but it's a very important issue. And we're not always going to agree on some of the recent gun legislation, but I think we can agree that when it comes to felonies and violent misdemeanors and people with mental illness, that this is an issue we have to address. What's most troubling to me from the auditor's findings is that the courts, in my opinion, are clearly not complying with the law, and the Department of Justice seems to be asleep at the wheel. And I think we all deserve better as Californians. The audit shows that too often the Department of Justice and the courts are failing to do their jobs. I've heard a couple comments already, but I want to make it clear that I support legislation that is going to address some of the audit recommendations and the required legislative fixes. One of those that's been suggested is to hold the courts to the same 24-hour electronic reporting requirement that AB 1131 imposes on mental health, treatment facilities, and law enforcement. But I think the audit shows that the problem is really with the DOJ and the court system, and we shouldn't need legislation, quite frankly, to do our jobs. I would like to leave here today with some reassurance that we're going to start working on this immediately. Legislative process takes a long time. If we have to do that, you know, we can go for that, but I'd like to have some assurances, and I have a few follow-up questions I want to follow up with, but with the safety of California in the balance, I believe that DOJ and courts, quite frankly, should be held to a higher standard. With that, Mr. Chair, if this is appropriate time, I'd like to ask a few questions.
Go ahead, sir.
Thank you. For the DOJ, there was a study back in 2010, a survey by the National Center for State Courts, and it issued a report regarding the state records estimate, development, and validation project, and used statistical methods to survey and try to determine whether these reporting processes were going forward in each state. And 42 out of the 56 jurisdictions participated, but California did not. Why did DOJ not participate in that study back in 2010?
I don't know why.
That's frustrating, that a study where 42 out of 56 jurisdictions participated, but California did not. I don't think that's a good enough answer for California. I think we need to get on the ball on this. What we're finding is unacceptable. Were you aware of the findings of that study?
I was aware of some of the findings of the study, yes, sir.
Okay, all right. I'm just going to stick to the most important ones.
And I can find out why we did not participate and get back to the office with that.
Okay, I would like that. I appreciate that. Okay. On the report that we received, it's indicated that the DOJ lacks responsibility in reporting due to lack of statutory authority. Isn't this done? Is this as easy as data entry or a phone call? What is so involved with the reporting?
Are we talking from the courts, or are we talking from the mental health facilities? In what context? I think we would agree that DOJ should have, and we will do a better job in reaching out to the entities that report to us to ensure that their information is timely and accurate, regardless of any statutory authority or lack thereof. We believe that the regulations lie in other entities, but we do agree with the auditor report that we're in a unique response or in a unique position to bring all that information together for public safety.
For the courts, excuse me. For the courts, that were unaware of the reporting requirements, will you be following up to ensure that appropriate policies and procedures are implemented? What are we going to do in the future in terms of reporting?
So we, when we learned of this audit originally and understood the how poorly the courts were reporting at the time, we reached out to all of the courts through the Court Executive Advisory Committee and the advisory committee to the Judicial Council that works directly with the presiding judges. We have implemented quarterly phone calls with the Department of Justice to look at court compliance. Courts who are not complying at that point, we will reach out to them to see if there is anything we can do to assist them in the compliance.
So are these new policies and procedures?
Yes.
Are they written where they can be shared with us in terms of what's going to be done going forward?
If you would like that, we can send you a letter that states what we're going to do.
I would like that. And then the issue of reporting and that it's going to cost more money, that's a key issue I want to touch on. Can you tell me what is involved in the reporting? It's my understanding that it can be done electronically by logging into the DOJ system from an internet cable device. Is that correct or not correct?
Well, there are several mechanisms that are in existence to report a variety of information, arrest disposition reports to DOJ. Many of the systems that the courts use are homegrown systems that have a portal that once an entry is made is then updated to Department of Justice. This is a little different. It doesn't have a specific component because it is a much more specific requirement. And so in order for, just speaking on behalf of my local court, in order for us to be able to make that transmission electronically, we would have to design certain aspects in our internal system to make that report. Our desire is to try to actually replace the system, and that's something that we're in the midst of reviewing right now so that we can have these types of communications to be done automatically without the necessity of a manual delivery of the information. And like I say, many of the courts have processes that are similar to mine, where it's simply taking the document. We have to verify that the information is sufficient so that the DOJ has the data to ensure that it's enforced and verify that, in fact, it's something that needs to go over. So just as importantly as reporting it, we need to make sure that the information is 100% accurate. So that's the secondary review that we've implemented locally, and I know other courts are doing the same thing, so that we are all in compliance.
Okay, then the follow-up question of the DOJ, is your system accessible? Can the courts log in, or do you need some type of special program? Could we have a demonstration of logging into the DOJ system and accessing it? Can the courts access your system? Really, I mean, I don't know how else to put it.
Well, I have some answers for that. As part of Assembly Bill 308, authored by then Assembly Member Bell, the Department of Justice was mandated to have our mental health reporting from the facilities based on electronic reporting. Therefore, it won't cost the facilities anything, and we get the information far quicker into our mental health system. That was fully implemented in July of 2012. That system is based off a secure internet connection. So from any internet connection, whether it's a laptop, a desktop, a iPad, you can have access to.
So the courts can access it?
once we provide them their training and get them the password and the information, yes, they can. There are some changes that have to be made to the system based off the type of reporting that courts have to do, but those issues are DOJ issues, and they're relatively minor. That system was based to get information as quickly as possible from the point of reporting, mental health facility, or in this case, it may be a court, to DOJ as quickly and cheaply as possible.
So you're telling me that with some training, the courts can access your system and have the information?
Again, we need to make some minor changes on our end, but yes. I think I talked to some staff members that it's a relatively easy process for us, and then training to the 58 court systems in order to get that information. Now, I'm not privy to what internal issues that the courts might have throughout California, but as far as reporting the information to us electronically, we can make that accessible.
Have you started talking to the courts and working with them to see what their needs are so that they can provide you with updated information? And if that's the case, how long does it take to enter information? How long would it take the courts to enter information into your system?
The first question is, we have contacted the AOC and talked to them about the starting of that process. As far as entering a person in, it really kind of is based on the information, how much information, but 5 to 10 minutes, 15 minutes tops per individual. We tried to make it as easy of a system to input information, and it's Windows based.
So we could be talking about not really needing 24 hours, but really needing 24 minutes. I mean, it's not that, doesn't take that long to enter information. And so my question also is, how long will it take? You said you've started discussions, and I appreciate that, because I want to get the ball rolling on this. I want this problem solved. I think it's embarrassing, quite frankly. How long is it going to take to let us know with some assurance that that ability for the courts to log into your system and enter this information is solved? Is it going to take a week? Is it going to take a month? Is it going to take a year?
As far as our part with the enhancements that we have to make to the system, I would say it's about 4 to 6 weeks to have that hashed out. We can do that with current funding that we already have inside the Bureau, so it's not going to cost anything additional. And we are in the process of making those enhancements. Once that's done, it would be a voluntary basis for the courts, like we did with the mental health facilities back in 2010 when we first rolled out our electronic mental health system. To then, it was voluntary up until July 1st of 2012, where it became mandatory.
Okay, then a follow-up question to the courts. How long? DOJ is saying that, 4 to 6 weeks we can get this open, provide you with access and training and get you up and running. Is that reasonable?
I think the courts are very open to exploring ways of reporting this much easier. This information is somewhat new to me. I was not aware that this resource was available. We're doing this on a manual basis right now. We would much prefer to do it electronically. And we're completely open to engaging in a dialogue to get this thing rolling out.
And as much as you'd prefer to do it, electronically instead of manually, I'd much rather do it that way instead of legislatively, quite frankly. I think that's the fastest. And so, Mike, I'm going to try to wrap up my comments. How much time do you need to work with DOJ and just get back to us on an update on your progress on this?
We can certainly do that in the next few weeks.
Okay, so we can have an update in a few weeks?
Be happy to report back.
I would be very grateful. Thank you. Thank you to all of you. Thank you, Mr. Chair.
Thank you, Assemblymember. Senator Galgiano, did you have a follow-up?
Yes, this is a little bit off subject, but back to the methamphetamine abuse since you're here. Those who are found in the court to have been addicted in possession of large amounts of methamphetamine, are they allowed to possess a firearm under current statute? Are they expressly prohibited from owning?
I'm sorry. An individual who has an addiction to substances is not allowed to purchase a firearm, but that is a voluntary statement made at the point of sale. So it brings it down to the
voluntary statement.
Yes. Unfortunately, people oftentimes lie about that
I have
at the point of sale.
Quite often.
So, yes. So when it comes to the prohibition as far as possession after the fact, again, we have to see a very clear history of substance abuse And when it goes to a court, again, it's based off of more if they're a danger to themselves or others, or if they go to a mental health facility, again, do they pose an immediate threat to themselves or others, in order for us to get that information and put it into our mental health system, thereby barring them from future possession of firearms.
You know, in my district in San Joaquin County and the Stanislaus County area, we have, since realignment, we have our jails are full, and we know what's happened with realignment. So lower level drug users who repeat over and over and over again, they go in for 24 hours and they're right back out on the streets. And it seems like it's pretty vague as to whether there's any way for DOJ to know that this is someone that's had a history for 20 years of meth use. They're not in prison, they're out on the streets because the crime hasn't risen quite to the level, but certainly after that many years of meth use, they are potentially a danger if they have a firearm. But it sounds like that's a vague area of the law. Would you agree?
I would agree that's a vague or gray area in the law that may need to be addressed.
At least maybe we ought to take a closer look at that. Thank you.
Thank you, Senator. I have a series of questions for both Department of Justice as well as the courts. I want to thank Senator Mansour for his line of questioning, particularly walking through just the mechanics of this reporting requirement and how the affected agencies work with each other and what challenges lay in the pathway of the courts in order to effectively accomplish that goal. One follow-up question I have is, you made the comment, sir, that 48 hours will be difficult to comply with, and 24 hours would obviously be even more difficult to comply with. What would be the substantive differences? I mean, both of those seem, whether we're talking about immediate, 24 or 48, I don't see the challenge in the difference. If you can comply within 48, I suspect you can do it within 24.
Well, one of the issues that was just presented today was the availability of this electronic mechanism to make that reporting. We will endeavor to do that. Obviously, putting together copies, putting an address on an envelope and mailing it off could be avoided if we're able to do that electronically. So that's something that is very welcoming for us. The preference, of course, is to have our systems speak to one another, so that when we enter a disposition on a case, we don't have to then take that information and then enter it into another system. So that would obviously expedite the process. But if this is a technology that is available to us, we will endeavor to try to comply with that. But as you saw from the report, some courts had difficulty doing it within 3 days, 4 days, sometimes it's a week. It comes down to volume and resources. And clearly we have thousands fewer employees than we did 5 years ago. And while we struggle to keep our doors open and keep courtrooms open as well, we have to prioritize our work. This is an area that we believe in. 48 hours is the law. That's something that we're going to try to comply with. And I don't want to have a situation a year from now where we realize that because of the resources, it's very difficult to even do the 48. So in many instances, we'll probably beat 48. But holding us accountable in every instance is going to be challenging, mainly because of the resources that we're struggling to hold on to.
I can appreciate that, although I think there's a compelling argument made in this auditor's report that there should be some consistency in the law and reporting requirements, and I would certainly suggest that mental health facilities aren't necessarily any less adequately funded than the courts and suffer from many of the same underfunded challenges that the courts have. So I think the question of whether or not we have a consistent rule across the board makes some sense. The remainder of my questions focus primarily in two areas. One is this issue of the timeline and reporting requirements. It certainly is an area of concern to me in reviewing the report, the timeline with which to finish this body of work. This is a matter that I think requires some urgency. I think the legislature and certainly the Legislative Committee would agree that we want to move forward as quickly and efficiently as possible. And some of the timelines I saw in the report seem vastly inadequate to me. The second thing is the second part of this question, which is getting guns out of the hands of folks that shouldn't have guns. And I don't want to get lost in the mechanics of the reporting requirements and lose sight of the ultimate goal, which is the safety of the public. And so the first question I'd like to cover is the historical backlog, the current status of that, and the timeline for eliminating the backlog. And that question is for the Department of Justice.
Thank you. When the auditors were at DOJ in August of this year, they listed the historical backlog at 380,000. In the past 3 months, we have been able to work a little over 47,000 off that. So it's a little over 15,000 per month. Our goal is to conduct 13,500 per month. That would eliminate the backlog within the next 25 months, a full year ahead of schedule.
And that date would be?
It should be December to January. It'd be December 2015 to January 2016.
Okay. What type and amount of resources would it require if we asked you to eliminate that backlog by December of 2014?
It would involve an increase. I could get you those numbers if that's something you would like me to do.
I'd certainly appreciate getting that information in light of the fact that the legislature appropriated additional monies to the Department of Justice in an effort to deal with these issues. I'd certainly like to know exactly what the needs are in order to expedite this process.
Is it all right if I get back to your office by this Friday?
That'd be great. Thank you.
Thank you, sir.
Could you go ahead and explain for the committee the July 2013 backlog of 20,800 persons identified as firearm owners who are prohibited from owning or possessing a firearm? I understand this is a fluid number, and I'd like an update on what the current number of identified prohibited persons is.
The current number as of December 1st was 21,265, obviously an increase. However, there was a decrease from the November numbers, which was at right around 21,380. So it's the first time that we've actually seen a decrease in the month-to-month numbers based off of our enforcement efforts.
And just to put that number in perspective for the committee and for the public, those are folks who have been identified as gun owners who are on the prohibited list. Of that number, who have we actually extracted the firearm from?
Yeah, a little confusing, but yes, those are...
How many of those folks no longer have that firearm in their possession?
Just in the last 3 months, we've done over 1,400 investigations, confiscating right around 900 firearms and about 200,000 rounds of ammunition.
So what's the what percentage, when you go out and conduct those investigations, what percentage of the homes actually do, in fact, do you find firearms?
I'll actually put it to my assistant chief, who's actually worked at every aspect of our bureau when it comes to APS enforcement, and he is our enforcement expert for our Armed and Prohibited Persons system.
Very good, thank you.
Okay, I think you need a little more understanding of how the system works.
Could you go ahead and state your name, sir?
Oh, I'm sorry. John Marsh, Assistant Chief of the Bureau of Firearms.
Thank you, sir.
The system has 21,000 people in it, and Chief Lindley just said that we worked 1,400 cases. What happens is a lot of the time enforcement will make an interdiction on somebody. They'll go to somebody's residence, they'll seize firearms, but they might have 10 firearms registered to them, and the agents might seize 8. So they disarmed the person, but there's still 2 guns in the automated firearm system still remaining in the system. So that person stays in the app system because we can't identify where all of their firearms are. So that's a little bit of the disparagement between the amount of cases to the number of of people in the system, because you would think if we did 14,000 cases, the number would come down by 14,000 or 1,400. And it's the number's not coming down as fast because we have to identify every single firearm that an individual has registered to them, or we will not remove them from the system. Does that make sense?
Well, help me understand that a little better. So,
okay.
If in fact you confiscate, your system shows the ownership of 4 firearms, and you confiscate 2, they remain on the list.
They have
you
to
confiscate 4.
If we disarm them from all of the guns that they have registered to them, they will be taken out of the system. It automatically kicks them out of the system. But if we only seize 2 of the 4, and we can't account for the other 2 guns, and they can't account for them, then we will not remove them from the system.
And then do they go onto a separate list?
They stay in the Armed and Prohibited system list until we can account for those guns. So there's other circumstances that those guns might turn up. If the gun was stolen or sold and then the gun is tried to be resold, then it would go through our DRO system and take it out of the person's name to the next person that's buying it. But if there's a multitude of different reasons why people don't have their guns anymore, and if they can't show us or tell us where that gun is, we don't take them out of the system.
But that certainly makes sense that you wouldn't take them out of the system until we've fully disarmed them.
Right.
What percentage does that represent of the folks that you investigate?
That stay in the system?
Yeah, that you are unable to complete the disarmament.
Of the people that we do interdictions on, where we actually seize guns, probably 50% of the people will stay in the system, if not higher.
That seems awfully high to me. Certainly, I don't know, would give the public a great deal of confidence that we're addressing the problem at a 50% failure rate.
Well, I wouldn't say that's 50% failure rate. I'm saying that we seize guns, we made a determination that they don't have any more guns to seize that we can identify at that time, but there's still guns unaccounted for that we can't remove them from the system until we account for those guns. But we did an interdiction on them, we seized guns, we did all the investigative work that we could do to make sure that they didn't have any guns and did follow-up, but there's still some guns that we can't identify where they're at.
Okay.
I think one of the key points is we have disarmed them. The unfortunate thing is maybe they sold a gun illegally 5 years ago. We've had individuals who, back in their younger days, possessed a firearm, and they sold it to somebody for a car, for drugs. They had it stolen, which we have no mandatory reporting of lost or stolen firearms. They don't know even what agency they were living in or that jurisdiction when that firearm was stolen. Therefore, until we can actually identify where that firearm is, we don't take them out of the system. Again, assuming that sometimes people lie to us, but we've searched the house, we've searched their vehicles, we've done our best job in order to disarm them, and 1 out of the 9 guns we can't account for. Therefore, we keep them in the system to ensure that maybe down the road some other law enforcement entity might have the ability to interdict them. He still might have the firearm.
But one could assume, based on your testimony, that of 20,000 targets, you may go through, disarm all of them, and still have 10,000 on the list in cases where you weren't able to locate each firearm. Is that correct?
That's correct, and we're looking at ways in order to delineate that from the overall system.
I'd also like you to help me better understand the process that you go through in enforcement. Obviously, you have agents at the Department of Justice that go out and conduct these investigations and engage in disarming the prohibited folks in the prohibited persons list. Do you cooperate with local law enforcement? Is the public's resources only your agents, or are we able to use other law enforcement officials throughout the state to help us in achieving this goal?
Anytime our agents go out throughout the state, we contact a local agency wherever we're working We've done collaborative efforts and done sweeps in specific areas. We've worked with locals. We've gone out and done training with local agencies. Local agencies have reached out to us and asked us how the system works. We'll come to their police department. I'll send a team of agents out there to work with their detectives. So anytime that the agents go out throughout the state, they're working with local agencies. The problem that we run into is local agencies throughout the state have manpower issues. And this is more proactive law enforcement, where a lot of local agencies have problems just responding to calls. And this type of work is very labor intensive. I know you've probably heard that, that it takes a long time to do. We have a lot of analytical staff that work up the cases prior to the agents going out. Then the agents work the cases out in the field, and then there's a lot of follow-up and things that happen with the guns after the case is over. So it's a very long-term process. It seems very short-term when they're out in the field because you're just looking to try to identify somebody and find where they're at. But there's a lot of work that goes in on the front end to make these cases and put the cases together, a lot of investigative work, then the field operations work, and then the follow-up after to trying to track down. In the example that we gave, we seized 8 of the 10 guns, where the other 2 guns are. There's a lot of investigative work that happens after the agents come out of the field.
Okay. Thank you for a better understanding there. I certainly am sympathetic to the process of the investigation and the fact that some firearms may remain unaccounted for, forcing you to leave some folks on the list, which is a good thing so that we can be vigilant in ensuring those folks don't come in possession of additional firearms or that those firearms reemerge. What I'm not so excited about is relaying the message to the public that we've got this huge backlog of paperwork to do, that we're going to take some years to do, and then when we get done with the paperwork, we haven't even gotten to the part where we're actually getting the gun out of the home of the folks that shouldn't have the guns. And I think we're going to need to do a lot better job as a state in showing that we're addressing this problem, I think, with more urgency, at least than my initial reading of this report suggests. How is the Department of Justice using the $24 million the legislature provided earlier this year to confiscate firearms and prohibited persons?
So far, we've been able to bring on an additional 21 agents of the 36, and as of February 1st, we'll have the remaining 15 agents on board.
Is there some way or some legislative action you could envision, I'll direct this to the Chief of Enforcement, where we could encourage local law enforcement to participate in a proactive fashion? Would that be helpful?
Any assistance we can get is always helpful. If we could have them assist, the problem is very specialized work, and the problem that we've run into is when the local agencies try to do these cases, I'm trying to give you an example that would make sense, but they'll just give it to the patrol guys out on the street. And I give an example. At any police department, there's usually a warrant box. And in the warrant box, there's just, you pull out a name, and it's somebody with a warrant. And if you go to that address, you usually don't find the person. And that's kind of what APPS is. It's a pointer system to a person, and then the investigation starts. So when local law enforcement's tried to do it, they'll push it out to street teams and say, go find these people, and they'll go out and they'll be unsuccessful because they don't have the time to do all the investigative work on the front end. So that's where the locals have had difficulties. When they work with us, it's been very successful, having extra manpower to do cases and being able to split agents and have them work with many teams and create kind of like task forces. We've been very successful in those circumstances, and we're very responsive to local police departments. During requests, they'll say, we want to eliminate all of the cases in our area that we could go out and do enforcement on, and we'll send a team or 2 teams out to their area, do target enforcement in specific areas. it would take a lot of coordination to get everybody doing it. We have offices throughout the state, and we're constantly working in different areas and trying to build relationships. And there's been a lot of focus, immediate focus on apps, and there was a lot of attention prior to probably SB 140 being the money being distributed. And then since then, there's been less attention from the locals as far as going out and doing it. But when we come to their area, we always contact them and give them the opportunity to come out and assist if they'd like to in their area.
Do you have examples of perhaps best practices with local law enforcement that members of the legislature could take back to the chief law enforcement officials in their areas to encourage cooperation?
I think best practice is any request for targeted enforcement in their area, because it's twofold. They get the cases in their area done, but they'll have a team, they'll have multiple teams out there working with their detectives, and it's kind of a training process as well as getting cases done. And then it can make them more familiar with the system, whereas if we just go out and provide training, if it's not hands-on work, sometimes it's forgotten. So when they get out and work with agents from the Department of Justice, they have a little bit better understanding of how the system works.
Okay.
Just to add, we do have additional strategies. We're looking at a program similar to the Deadbeat Dad program. It's going to take some legislative work, but if we can tie people from the apps system into state, like registration of your vehicle, and tie it to some kind of monetary issue, we believe that could help to entice people to turn over their firearms. So that's something that we're also looking at.
Well, I know the authors of this particular audit, including myself, including Assemblymember Mansour, certainly would appreciate if you'd bring that information to our offices as you move forward and see how we can be helpful in making that work better for you in the enforcement side of this. When does Justice expect to get through? We've talked about getting through the list in so much as understanding that the list has been combed through, but then also executing the enforcement of it. What's the timeline for that? Do we have some idea?
Our target is to conduct 7,000 investigations per year.
7,000 per year. And how many thousand are we going to have to go through? Can we make a...
Well, if we can keep the system currently as it is, and like I said, that was our first opportunity starting December 1st, that we have not seen the system go up from month to month. So at least we're addressing what's coming in on a monthly basis. From there, we're going to be moving forward with knocking it down on a monthly basis.
So, but we had, what, 380,000 to go?
Are you talking about the historical? The historical backlog is dealing with trying to identify individuals who, prior to certain data enhancements that we have, may or may not be armed or prohibited. With that, we can move forward with talking to your office. Like I said on Friday, I'll get back to you what it would take for us to get that down to zero by December of 2014.
Including enforcement?
Enforcement is far trickier. It's going to take.
That's the question I'm asking. Obviously, okay. You told me you'll get back to me, and we'll get through the list by December 2014 if we had X resources. And I'm asking the next stage question is, okay, we got through the list and we went out and conducted all those investigations as thoroughly as possible, obviously with the caveat that some may remain as open cases.
Well, we can do about 7,000 a year with this current funding that we're receiving through SB 140. If you wanted to address all of that in 1 year, we'd probably have to triple that.
So we'd probably have to do
21,000, about 21,000 per year.
That's assuming the list stays stable as you comb through those other 380,000?
Correct. There's also other issues that are affecting that going long term. One, we've seen unprecedented gun sales the last 3 years. Went from 600 to 800,000 per year. We're going to see over 1 million firearm transactions this year alone. On top of that, we're going to have long gun retention starting in January 1st of 2014. Historically, long gun and handgun purchases going back to 1993 is roughly 50% each. So right now, we're only capturing people in apps that registered an assault weapon since 1989 or purchased a handgun since 1996. It leaves a large chunk unaddressed. As that long-gun retention goes forward, we can see a doubling on an annual basis of the APPS system.
But you could get, based on your understanding, you could get me the information as far as the resources you would need, not just to get through the list, but then to execute the enforcement within 1 year's time?
Yes.
Whatever that would require, obviously additional agents and resources would be part of that conversation.
Yes.
I'd appreciate you doing that. Thank you. Now to move to the court questions. Oh, excuse me, Senator Galgiani.
You said that the increase in handgun sales or firearms altogether went from 600,000 up to. Can you repeat that for me again?
It's going to be a little over 1 million. For instance, when I came to the Bureau of Firearms in 2007, I believe the firearm sales in California was right around 362,000. We've seen a steady increase year after year. The last 3 years, we've seen increases of 200,000 per year. With this year ending, and I'm talking calendar year, a little over 1 million firearm sales. That is in line with the increase in firearm sales nationwide as well. But there's a lot more gun owners in California than there were a few years ago.
If you were to get the resources to be able to address the backlog in the system, do you have the ability to either contract with local law enforcement who otherwise might be losing some of their officers due to budget situations, or do you have the ability to do like immediate transfers? Because I'm thinking about our situation in Stockton, where part of our problem has been not just that we didn't have the positions, but the turnover and the amount of time required to hire personnel and have them go through training and so forth. So it seems to me that maybe the issue isn't strictly about money, but if we were to provide the money, that there would be a gap in time in which it would take to hire personnel, get them trained, etc. But if you had an ability to just have those in local government, law enforcement in place and able to do the work, that would help make it happen faster.
We suffer from the same issues when it comes to hiring, that it takes some time. Going back to, or talking about Stockton the last year to 18 months has done an excellent job with not only working with the Department of Justice on APPS offenders, but just in lowering violent crime associated with firearms. I think considering the challenges that they've had, they made excellent progress and somewhat of a model for other parts of California.
Agree.
We have partnered with Stockton PD on a number of issues, particularly with our Armed and Prohibited Persons system. As far as our ability to, what would be kind of a grant program, that would be something for the legislative body to provide that money to DOJ in order to siphon out to local agencies as far as enforcement of APPS or other firearm-related investigations. But there is that mechanism in place. It's a funding issue.
But you can include that recommendation when you report back to this committee as to what type of resources and how that might be implemented in order to accomplish this goal within 1 year's time.
That might be a little more challenging. We can talk about some maybe best practices, and then it would be kind of up to the level of what the legislative body would want us to do. We can talk about if we were given $1 million in grant funding to provide to local law enforcement agencies, either for overtime or for officers to do that work, and that is something we could talk about. We've also talked about providing monies to law enforcement agencies to enter firearms into the automated firearm system, which they fail to do due to staffing levels. That also would provide them some information about tracing of the firearms as well, and get a better understanding of where the firearm is coming from. Agencies that have done that successfully, Richmond, Stockton, LAPD, have done those type of resources and give them a better understanding of where those firearms are coming from and target the investigations towards the problems.
Okay, thank you. I'll wait to hear back from you with the best information obviously available to you.
And whatever questions that you have going forward, please contact me, and we can work on any issue that you have related to this Armed and Prohibited Persons system.
Very good. Members, Assembly Member Mansour.
Thank you. A very brief question for DOJ. regarding a letter that you sent to ATF regarding California's firearm restoration process.
Yes.
And clarification on whether ours is compliant with federal law, for lack of a
Correct.
word. You have not received a response yet?
We have not received an official response. Our attorneys are talking, and we are expecting a somewhat of a, we're working on it, letter from ATF and from the FBI here shortly, but it is somewhat of a complicated issue between our state laws and federal laws, so we're looking to work with them on that, but I expect that the response from ATF or FBI might be, take some time.
How much is some time?
6 months to 9 months response. So, sorry.
Can you keep us updated on that, please?
Yes, as part of the regular audit process, we will. Anything that you, as a committee member or as a body, want from us, we will surely can respond quicker with that.
Thank you.
Any additional questions, members? With that, Madam Auditor, thank you for your work on this issue and your presentation. Certainly, Department of Justice, the courts appreciate you being here and working through this issue and your continued involvement in helping us ensure that we get through this list and, most importantly, we get these guns out of the hands of folks that shouldn't have them. So thank you so much.